to our property tax exemption seminar. I'm Erica Spangler-Raz. I'm a staff attorney with the Law Project. So I'm going to tell you a little bit about the Law Project and then kind of give an overview of the purpose for this seminar. So the Law Project is a pro bono transactional legal services organization. We recruit volunteer attorneys to do legal work for community-based organizations that are serving low-income or underserved groups. And if you're interested in our services and the eligibility requirements, you can go to our website, www.thelawproject.org, click on apply. And we do have online applications for organizations now. Very excited about that. We also provide educational seminars, and we're doing them about once a month now on topics that are of interest to our community-based organizations and small business clients. For this one, the purpose of this seminar is really to give you the basics of property tax exemption. Oftentimes, our nonprofit clients come to us and they have questions about developing property for example, an affordable housing purpose, or they may be receiving donated property that they wish to transform to renovate into a community center. But the assumption is that they are going to get property tax exemption, and they don't know what the process is, how long it takes, how much it will cost. And so this is really to give that information to help nonprofits in their planning when they are in the strategic planning process for these initiatives. So with that, I would like to introduce Nick McIntyre from Warsick and Vihan, and Bill Skalitsky from Applegate Thorne Thompson, who's going to be sharing their expertise and volunteering their time to do this. So first I'm going to turn it over to Nick.
Well, good morning, everyone. Good morning. My name is Nick McIntyre. I'm a property tax attorney with Warsick and Vihan. Mostly we do valuation appeals, but I've done a number of property tax exemptions, and from start to finish. So because we have a small group tonight, this morning, we're going to field questions as they come in. And what I understand is we already have two. So to whoever out there asked these questions, I will take your questions. The first is as to donated property. Is there a waiver on back taxes? And the answer on that is not really. Back taxes are going to be a lien against the they're going to be against the property, and the ownership is, as far as I know, kind of irrelevant. There may be something to do with changing the valuation. There are ways to go back years on property tax assessments, depending on where the property is located and what it was used for, what the valuation was at the time the taxes were owed, but those are all really situation specific. But so generally, the answer to that is no. The second question has to do with abandoned property and whether there are waivers of taxes due to age or abandonment period. The answer to that is an asterisk no. There are not waivers of back taxes per se, but there are certain incentive classes at the assessor's office that abandoned property potentially would qualify for. So there would be a way to limit the tax liability going forward for abandoned or long vacant property. Anything more specifics, and I may be able to give you more of an answer, but that's the answer right now. Anyway, so we're going to launch into the basics of the non-homestead property exemption. Non-homestead because it differentiates from the homeowner's exemption that everybody is fairly familiar with. Always two threshold issues with a property tax exemption in Illinois. One is ownership, who owns the property, and one is use. How is it used? Pretty straightforward. Ownership and use are the two things that will always come up. Now, for the non-homestead exemption, there are really two primary categories. There's religious use exemptions and something that's shorthanded as charitable use. Those are far and away what most exemptions are granted under, is one of those two parts of the statute. There is a third sort of category, which is their specific types of property and specific uses that are enumerated in the statute, which you may qualify for, but these generally are the two that most groups are going to qualify for. So the first is religious use. Religious use is use only. It really only cares how the property is used. If it's used exclusively for religious purposes, school and religious purposes, or orphanages, orphanages is a historic category mostly attributed to the fact that orphanages were generally run by religious organizations. But that's the big thing to know with religious use, is that it is use only. Charitable use requires use and ownership, making it very different. So there's several steps in the analysis of whether your property would qualify for a charitable use exemption. One is the institution that owns it has to qualify. It has to be an institution of public charity or a beneficent and charitable organization. Second is the use. It has to be actually and exclusively used for charitable or beneficent purposes. Exclusively, in this case, means primarily. It doesn't mean exclusively. It doesn't have to do, ancillary uses, secondary uses are usually immaterial. Okay, so first, religious use exemption, as we said, it's use only. Examples: churches, synagogues. I've done one for a meditation center, and parochial schools are all things that would qualify under religious use. One of the big things to know is the property cannot be leased or otherwise used with a view to profit. Now, this is a phrase that comes up in this part of the statute a lot. Leased or otherwise used with a view to profit, in a general sense, means you can't be leasing any portion of the property for more than a nominal amount. If it is an income generator, then it most likely doesn't qualify for a religious use exemption. And then as to whether your entity would qualify as a religious organization, it's worth noting that federal recognition is important. It does weigh heavily, but it's not the end-all be-all. Illinois has its own categories for determining whether an entity meets those requirements.
Can I give a question?
Yes.
If there's if it is leased, is there any kind of court decisions or anything that gives you an idea of what nominal means?
Oh, can I just interrupt? Because it doesn't pick up on the webinar, can you repeat the question before you answer it? Yeah.
Sorry. The question was whether there is whether there are court decisions saying what nominal means. There are. Nominal is going to have to be, I can't regurgitate them offhand, but or like in whole, but
Right.
generally it's going to have to be well below anything close to market value. Most nominal leases are $1. You see that a lot. It's $1 a year, or $1 a month, or whatever. But that it would have to be obviously nominal. If that's kind of answering your question.
Right.
Okay.
Okay. Yeah.
So it can't just be cheap.
No, right. It can't just be cheap. It needs to be obviously not an income generator.
Yeah, a question from you.
Oh, and we have another question online. Okay.
If
Just
my
raise your hand like you're the one asking.
if my nonprofit office space is in my place of residence, can I receive a property tax exemption? I do, however, hold my small groups in the lower level of my home.
That is an interesting question. So, can the people online see those?
The people online can
Might
see the
that.
questions.
Yeah,
Yeah.
they can see the questions.
Okay. So as to whether your home can receive exemption if your nonprofit office is there. I have not had this come up before, but my inclination would be that it can't. You have to remember, it's going to have to be
Owned by the nonprofit? Or no?
no. It's use only.
Oh, for religious.
But it has to be the primary use, and the primary use of that property is as your home, not as it's not a primarily religious use. Was it a religious or a charitable question? I'm sorry.
Didn't say. If my nonprofit office
Okay.
space.
Well, we'll do it this way. Either way, most likely your home's not going to qualify. There are situations, this comes up a lot, where if the Department of Revenue can divide the property into something that would qualify for an exemption and a part that wouldn't, they will do that. So you could have a property that qualifies for 1/3 of an exemption, or 2/3 of an exemption. 2/3 of the property would be exempt, or half. That comes up. I don't know if that would qualify in this, if that would really make sense in this situation, but that's a possibility. If there is a portion of the property that is primarily used as the office of your nonprofit, then maybe. Okay, onto the charitable use exemption, which is probably what most people are interested in. Charitable use requires ownership and use, as we said, ownership by an institution of public charity or beneficent and charitable organizations. The statute enumerates a couple other ways you can be a charitable organization, but that's primarily how they define it. And actually and exclusively used for charitable purposes and not leased with a view to profit. Again, exclusively means primarily for purposes of the property tax code, and not leased with a view to profit means really can't be an income generator. So the first step in determining whether a property may qualify for a charitable use exemption is determining whether the entity would qualify. This was an analysis that was put down in a case called Methodist Old People's Homes v. Corzine. So it's a five-prong analysis. First is the entity has to have no capital stock, or shareholders. I mean, obviously that looks a lot more like a business than it does a charitable organization. The entity can earn no profits or dividends, but rather derives its funds mainly from public and private charity and holds them in trust for the objects and purposes expressed in its charter. Again, this is something that is basically common sense. That will look a lot more like a charity than a business. If you earn profits or dividends, and that's the main source of your funds, then that is going to look like a business. Okay, this is a big one. Dispenses charity to all who need and apply for it. A big part of the Corzine analysis is whether there are barriers to accessing the charity, whether there are barriers to the clientele, as it were. The more barriers, the less likely it is that the organization is going to qualify.
Can you clarify the barriers? If resources are insufficient resources, like for example, I'm trying to think of something. If it was a food pantry,
well, here,
and they had no more food to give out,
no, that would not be a barrier.
Okay.
This came up in there was a big hospital case that came down 2 years ago.
Oh, okay.
Yeah.
Yeah.
Provena,
Yeah.
and
Okay.
basically money was, I mean, to sum it up, money was was a barrier to access
charity care.
the
Got it.
charitable care from the hospital. I mean, among other things. Mainly, they weren't dispensing charity, really. They were a money-making hospital. That was the distinction. Next, you're right. Does not provide gain or profit in a private sense. Again, these are all pretty straightforward. I can't think of a situation where this would be problematic. Not anything that I've come across. But if someone owns the charity and is making profits as opposed to a salary, that would be probably enough. And finally, the obstacles goes along with dispenses charity, all who need and apply for it. The more barriers that are in place to the public and those who need it accessing the charity, the less likely you are to qualify.
So as more and more nonprofits look at trying to come up with social enterprises or income streams to support their activities,
Mm-hmm.
is that going to create more and more barriers to obtaining real estate tax exemption because they are actually making money?
All right, so the question was whether as nonprofits work to develop more income streams and more revenue generators, whether that will be an issue with gaining property tax exemptions going forward. My inclination is that would not. I don't. I mean, it depends. The nature of the activity is going to be a big part of it. But if it could be qualified as essentially holding money in trust for the things they need, if they're not, pulling profits off the top or dividends or that kind of thing, it would seem to me that that would in most cases qualify. Again, it's a specifics thing. Depending on how closely the revenue generator is associated with the mission, how closely it's associated with the organization. Is it just an investment? If it's that would be different.
Is that true also if they charge for their services? So we have an application fee and it's on a sliding scale and it says we'll waive it. Circumstances.
All right, so the question was whether charging for any services is going to be problematic in getting a tax exemption. And what this woman said was they have an application fee on a sliding scale and it says we'll waive it. That kind of language is usually going to be good enough. Okay. It comes up, a frequent one with housing. In most housing that qualifies, and you would know better, it'll say we're not going to kick people out for lack of ability to pay.
Right, that's one thing we'll talk about later is the so-called non-eviction policy.
Yes. So, right, any language like that, as long as the organization acts in accordance, would work just fine.
Thank you.
Okay, so we've basically gone through the cores and the analysis. So this is the first part. It figures out whether your entity would qualify as a charitable organization for purposes of the statute. Then the next part is ownership. So the question, does the entity own the property? I know a lot of people are going to be from organizations that lease property or have an interesting financial arrangement regarding how they occupy their space. Ownership for purposes of property tax exemptions is equitable ownership. It's really control of the property. It's not your name on a deed. There are very interesting ways to work out how a charity goes about owning a property, occupying a property, etc. And name on a deed is not I mean, that would obviously name on a deed would work, but there's plenty of other ways that a charity would qualify as owning a property without having their name on a deed. Okay, and the next aspect is use. Use, it has to be actually and primarily used for charitable purposes. Normally, these are going to be the things that are listed in your charter or your bylaws. They have to, some of the language, now these are charitable use. The use portion is a little bit fuzzier than the ownership portion, but a lot of the language that you see out there is, does the use serve the public interest and lessen the state's burden? There's probably a wide berth for what use would qualify. It overlaps a lot with the ownership guidelines, but no, the use is important. But if it's in your charter and you qualify as an ownership entity, and then you act in accordance with your bylaws, your charters, that kind of thing, then your use is most likely going to qualify also. Yeah.
Could you give us an example of equitable ownership?
The question was, can we give an example of equitable ownership? I cannot.
I've got one. So
Okay, Bill's got one.
there was a credit financing structure in a case a number of years ago where the not-for-profit owned land but couldn't really finance it, so they did a sale lease back. So they sold the property and then to a for-profit and then leased it back, and you continue to use it for its charitable purposes. And the court, that was the big question, is who actually owned the property? And the court said, we're going to look through this sale lease back to actually who has, possession and control and those kind of equitable interests in the property. And so they said, because this whole transfer, the sale leaseback, resulted only because of the need for financing, we're going to disregard the fact that this for-profit actually owns the property, and we're going to look to the leaseback of the property to the nonprofit. So that's an example of a situation where the nonprofit doesn't technically own the property, but it's considered to be the owner for purposes of the charitable property tax exemption that it ultimately won.
So, and that would be like an equitable mortgage then.
Yeah, so they had a mortgage against their leaseback interest. And another example is I'm working on a project where I actually have closed a couple of projects where Catholic Charities, for example, leased property from another not-for-profit organization, and they built on that leasehold estate a Section 202 multifamily housing for very low-income elderly persons. So in order to get the property tax exemption for this leasehold estate, which there were mortgages against the leasehold estate in connection with their financing, we actually had the owner of the property, which was another 501c3, submit an affidavit saying, we are the charitable owner of this property, and we are satisfying the charitable use requirements of this property by leasing it to Catholic Charities. And then Catholic Charities also submitted an affidavit saying, here's how we are charitably using this leasehold estate. And they listed, that they created this affordable housing project. It's for persons elderly making 50% or less of area median income, etc. And they provided support services as well. So the court, because taxation is at the fee estate, so the fee owner is the person that has to pay the taxes, and that's who the exemption would be issued in the name of. The Department of Revenue actually said, okay, here we have charitable ownership through this one 501c3. We have charitable use through the second 501c3 and how they're using it. So we're going to grant an exemption for the fee estate. And then what the ground lease said is that Catholic Charities would have to pay any taxes on the fee estate. So as long as the fee estate was exempt, that exemption effectively passed through by virtue of the lease language to Catholic Charities.
And there's no nominal lease amount.
There was $1 a year for that ground lease. But again, that was the first thing the Department of Revenue looked like. Where is, they're looking at the 40-page ground lease, where's the rent section? And the first thing they saw, $1 rent, and they're like, okay, we see it's a nominal rent, and that, that item is checked off their checklist of things they evaluate.
Thank you.
Sure.
Yeah, dollar is easy. It's presumptive, I think, for most of the Department of Revenue.
Sorry.
Anything more than that's going to be.
So if it's a for-profit owner on title renting to a not-for-profit, and not-for-profit has a lease and is using the property for its mission, can it become tax exempt?
I've not actually had that scenario.
Okay.
The the way the property tax code is set up, again, is that the fee estate is what gets taxed.
Mm-hmm.
So there is an exception where you can create leasehold pins, where the leasehold itself
Oh, really?
has a property identification number, but it's very narrowly limited. And the context that I see it in the affordable housing world is when there's a municipality that is leasing the property,
Okay.
because the municipality has an exemption by
Right.
virtue of the municipality's ownership. And that exemption doesn't change whether it's leasing the property or using it in some other, giving some other interest in it. So the assessor's office in those circumstances will create a PIN for the leasehold estate, and then you pursue an exemption for the leasehold PIN. If you can go that route, I think you're great. I think you probably have an uphill battle though if you have a for-profit that owns the property and is leasing it to you. Except for the circumstance
Right.
that I gave where it was unique financing,
Right.
there was no other way to go about creating the charitable structure that was needed, and through the sale leaseback example.
Okay.
But I've never, in my little niche, I don't have
Right.
to address that issue. So
So just so you know, with the leasehold estates that Bill mentioned, I've never seen that in a way for a PIN that isn't owned by the government in one way or another. So really, it's everyone who leases space at O'Hare. It's everyone who leases space at the Thompson Center. It's the Water Reclamation District leasing to construction companies. That's almost exclusively. I can't even think of a scenario where you would have a leasehold estate otherwise. All right. So with that, right, use flows from the ownership portion. Again, this is it's a pretty common sense analysis. Right, common sense approach. It's a flexible analysis. It's holistic. It's how it takes a look at the whole of how the property is used. Does it meet the cores and guidelines and act in accordance? And then I had mentioned before that there's specific exemption categories. So besides charitable use and religious, there's a whole laundry list of things that are in the statute. Things as specific as the Joliet Arsenal Development Authority. So if you're out there and you work for the Joliet Arsenal Development Authority, you should go ahead and make sure your property is exempt. To schools, cemeteries, library districts, etc. But again, most everyone's going to qualify under the charitable use and religious use portions. Okay, and then real quick, we're going to go through the exemption application process, if you guys haven't done it before. So by statute, the Board of Review in the respective county where the property is situated is the first step. You file your exemption application and all your documentation with the Board of Review. They make a decision on it. It's not really a decision though. They are essentially and this is in Cook County, but really most of the state, they're essentially a clearinghouse for documentation. They make sure you have sufficiently proved up what you were trying to prove up before they send it to the Department of Revenue. And I'm sure, I believe a recommendation goes with it, but they're by no means the final decision maker. Then goes to the Department of Revenue, which will issue a decision letter stating property 0% exempt, properties 100% exempt, properties 2/3 exempt. There is an appeal process with the Department of Revenue. There's an informal process where you can reach out to the Department of Revenue. I've done this on a number of occasions, and talk with the person who made the decision, the attorney who was looking at your file, and see if something needed further explanation, etc. There also is a formal hearing process if that doesn't work. Then, assuming you have gotten your exemption, the next step is the assessor. The assessor is the one who implements the exemption. As soon as the DOR grants an exemption, they notify the assessor's office. We also, just to do our duty, send a copy of the decision letter to the assessor's office. So the assessor will get the decision. It should go on the books for the next year. It's usually, like, say, if it comes early 2014, it's not going to go on until 2015. Depending on how long the entity has owned the property, there may be a possibility of certificates of error. Certificates of error are more common in Cook County than they are in other counties, but essentially it's going backwards and correcting assessments. So if you've owned it since 2010 and been using it the same way and you didn't get your exemption granted until 2012 or 2013, there may be a chance you may be able to go back and get the exemption retroactively installed by a certificate of error to 10, 11, and 12.
And the one good thing about that process is the decision maker on the retroactivity is the assessor's office. You don't go back to the Department of Revenue. So once the Department of Revenue issues the decision, you're basically done with them, and then you're asking the assessor, again, proving up that you've had the same use that's been found to be charitable. If you prove that for the last 3 years, you can get the exemption applied retroactively and then get a refund of the taxes that you previously paid.
And then the last part of dealing with the assessor's office is once your exemption is granted and installed, there is an annual affidavit that the assessor's office will send you, and you will sign attesting to the fact that the property is used the same way it has been, and it was used the whole year the same way, and there's no real substantial changes, ownership, use, etc. And I think that's it from my portion. I think I'm going to hand it over to Bill, who's going to talk about low-income housing.
So my name is Bill Skolitsky. I'm an attorney with Affidavit and Thorne Thompson here in Chicago, and our firm primarily does affordable housing development or community economic development. A lot of it's driven by the federal low-income housing tax credit or the new markets tax credit. I actually became involved in property tax work kind of as an aside. I mainly am a real estate bricks and sticks attorney. But we have had projects where they've needed to pursue a property tax exemption in order for the project to work financially, and so it's a great way to help sustain affordable housing once it's been developed, because you're eliminating obviously an expensive cost of the operations of the project. To really kind of understand affordable housing and property tax exemptions, it's probably helpful to kind of go back in time a little bit to understand this trajectory that we've been on with the Department of Revenue in developing kind of the rules and guidelines for pursuing charitable property tax exemptions in the affordable housing arena. So as Nick was saying, when you're pursuing a charitable property tax exemption, you need to make sure that you qualify under the statute. There's a specific section of the property tax code that speaks to the charitable exemptions. And then you also have to go through that Corson analysis, what's often called the constitutional analysis for a charitable property tax exemption. And the reason why you go through this Corson analysis or the constitutional analysis is that the ability of the legislature to create a property tax exemption actually comes out of the Illinois Constitution. So the courts in the Department of Revenue say it's great that you may have a statutory ground for an exemption, but the fact that you can say, I qualify under Section 65C, they're going to say, well, that's not enough. You actually have to prove to us that you're charitable under our constitutional analysis. And the way they articulate the constitutional analysis is through the Corson decision, and there have been a host of decisions since that one. I think it was 1964 when that came down. The most recent and significant of which was the Provena case that he mentioned. And in all of those cases, the courts are always looking at these, it's sometimes referenced as 5 factors, or sometimes it's called the 6 factors. And the courts make you go through, and the Department of Revenue make you go through and prove that you meet each of those 6 constitutional requirements in order to qualify for a property tax exemption. So going back in time, the Illinois Constitution, I think, was adopted in 1970, and they immediately created, or actually they preserved the existing exemption statute because that predated the 1970 Constitution as well. In 1987, there was an important amendment to the property tax code where the state legislature recognized that housing developed under HUD's Section 202 program would qualify for an exemption. And the Section 202 program, I referenced it earlier, at that time in 1987, it provided housing for very low-income seniors, and it also provided housing for persons with disabilities. They didn't need to be elderly. You could just, I think you had to be older than 18. So that was the first significant change. And then in 1996, there was an amendment to the Act to address the low-income housing tax credits. So the low-income housing tax credit came into effect in 1986, and it's a way to stimulate and finance affordable housing development. And so in 96, they passed a simple amendment to the statute saying that the fact that that a charity owns a project through a limited partnership or a limited liability company because they're using low-income housing tax credits, that's not going to disqualify them from getting a property tax exemption as long as the general partner of that project is the 501c3 or the 501c3 controls it. So let me step aside for a very quick 101 on tax credits. So the idea of the federal low-income housing tax credit is you get $1 credit against your federal income tax liability. It's a competitive process. So Erica, or let's say Nick is my not-for-profit developer. Nick is going to go out and apply to the Illinois Housing Development Authority or the city for an allocation of low-income housing tax credits. And his project is going to be one of maybe 20 that they're evaluating, and they will give Nick points based on what he has in his application, and the highest scorers get the credits. So Nick gets an award of credits. He doesn't want to keep them for his own property, for his own federal tax liability. Instead, he wants to sell them. So he may sell them to Erica. Erica, you are the investor now. You're going to give him maybe 90 cents, 95 cents on the dollar. So you're recognizing a little bit of return. You're getting $1 credit. You're paying something less than that for that credit. And you're giving Nick the money that he needs to help finance this affordable housing project. And tax credits generally account for about 50 to 60% of financing for affordable housing. So Nick's also going to go out and he's going to talk to the city or the state to get additional money, maybe a private lender as well. The tax code, though, requires that the recipient of the credits has to be in the ownership structure, and that's why that gets complicated for charitable property tax exemptions. So we create these limited partnerships or limited liability companies in which we've joined our nonprofit charitable entity with our for-profit investor who's buying the credits to ultimately use against their tax liability. And we create this joint venture partnership, and we document it again through a limited partnership. So the project is going to be owned by a limited partnership or limited liability. And when you look at it on its face, getting back to the sale leaseback, this is a unique financing structure that we've created. And we ask the Department of Revenue to look through the financing structure to say, okay, who really controls this entity? And they get comfortable that the 501c3 controls it if Nick is the general partner, because the general partner is responsible for the day-to-day operations of the partnership. So if you're the 501c3 and you have that, you're the sole general partner, then the Department of Revenue will look through your limited partnership structure and say, okay, what is the general partner of this 501c3 doing? Is the use of the property consistent with its charitable mission, et cetera, et cetera. So back in 1996, the legislature amended the statute to say just because you're doing a tax credit project, you may have limited partnership ownership, we're not going to disqualify you. So that provision of the statute went into effect and just kind of languished. Nobody really. There was one client that got an exemption. You know, somebody passed that for a particular project, and then nothing really happened for a while. So in the affordable housing realm, most of the property tax exemptions came in the context of Section 202 projects, where HUD is providing mainly the financing and the rental subsidy to help sustain these projects. I got involved in affordable housing in about 2000. One of my partners, Mark Burns, who's been doing it since the 1970s, said, you know, prior to 2002 or 2003, these property tax exemptions were really rote. You submitted an application saying, we're a 202, here's evidence of the financing, and then a couple of months later you would get your determination letter that Nick mentioned. The Department of Revenue put the brakes on granting these exemptions in about 2003 or 2004 and said, wait a minute, it's not enough that you qualify under the statute. We're going to start analyzing all of these exemption applications under the constitutional, the 5 or 6 prong analysis of Corzine. And so at the time, HUD was actively involved because this obviously, the inability to get the property tax exemptions for their projects meant that the cost of operating their projects was going to rise significantly. So HUD got actively involved and worked out with the Department of Revenue the idea of a non-eviction policy for demonstrated inability to pay rent. And I'll go into that in much greater detail a little bit later. But that was the fix. So once that fix was in place, the Department of Revenue started processing property tax exemptions again. And then in about 2005 or 2006, they again put the brakes on property tax exemption applications. And this was in the context of what are called Section 811 housing projects. So Section 811 is housing for the disabled. Again, very low income, so they have to make 50% or less of area median income. And the department had 2 principal objections. One was that there was nothing in the property tax code that spoke to an exemption for Section 811 projects. It only spoke to Section 202 projects, nursing, old age homes, and there's a litany of things, but there wasn't a specific reference for Section 811. And then the second thing that they objected to was the fact that in Section 811 projects, like the Section 202 projects, HUD gave the developer the capital advance money needed to build the project, and then HUD also gave the rental assistance needed to sustain the project. So if you're a tenant of one of these properties, your rent is not going to be greater than 30% of your income, your adjusted income on a monthly basis. You are not paying that full 30%. You may be. Oh, I'm sorry. Take that back. The cost to operate the unit may be $500 a month, and the tenant is only paying 30% of their income towards that $500. And so usually the tenant is paying $100, $150 because that's all that they can afford under this mathematically calculated rent payment. So you have to come up with the other $350 to $400. And so HUD said, we're going to give you rental assistance in the form of this project rental assistance contract so that you now have the $500 that you need to cover your cost on that unit, and then you multiply that by the number of units in the building, and that determines the amount of subsidy that you get. So the Department of Revenue said, well, wait a minute. What are you doing, 501c3, in this project on a charitable basis if HUD's giving you all the money to build it, and they're basically giving you all the money to operate it? Where's the charity? And their buzzword was, what's your skin in the game? We were able to resolve the first problem about the Section 811 versus the Section 202 in the property tax code question by going back to the 1987 amendment that we talked about. At the time the Illinois legislature passed that amendment in 1987, the Section 202 program was for elderly and disabled. And then in 1991 and 92, HUD kind of bifurcated the 202 program into creating the 202 program that was exclusively now for elderly, and they created the 811 program to address the housing for the disabled. So the DOR got comfortable that, in fact, Section 811 was really, an offshoot of what was originally approved back in 1987. So that was the easy issue. The more difficult issue was proving how you could be charitable when the government was giving you most of the financing. And so we focused there on demonstrating how all this subsidy that's being provided actually helps, getting back to the Korsen test, reduce the burdens on government. There has been some good empirical social science studies that have been done, and there continue to be done, showing that when you house people with supportive services, you are actually saving the government money, because you're reducing, for example, the number of emergency room visits, or you're reducing the likelihood of incarceration and the costs associated with incarceration. So there's all these social benefits that are recognized when you create stable, safe, supportive housing. So we were able to convince the Department of Revenue to look at kind of the broader social consequences and savings associated with it. And then the other important thing about these 202 and 811 programs is that they really are an act of charity by the sponsor. So when Nick goes out to develop his 202 or 811 program, he does not get paid a developer fee. He's not getting any money for doing this work. He's investing all of his staff time in creating this housing and then managing the housing. There's a small management fee that he will be paid, but usually these projects were pretty much at break even. You know, nobody was making money.
Yeah.
They weren't really losing money. But when they lost money, Nick had to come out of pocket to actually sustain the project until HUD could eventually reimburse them. So the department, we could show that, you know, Nick and other 501c3s, they had generally $50, $100, $150,000, $200,000 of support that they were giving to these projects, not on an annual basis, but kind of on a cumulative basis. And then that money would get reimbursed somewhat, but from HUD, but usually not dollar for dollar. So he was always carrying a balance on his books for the subsidy, and the Department of Revenue said, that's great. That's evidence of having skin in the game. So they got comfortable with the Section 811, and they started again flowing these property tax exemptions. And then we speed forward to about 2010. And in 2010, we had, actually it was 2007 to 2010, there were a couple of projects that were pursuing property tax exemptions where they had been financed with the low-income housing tax credit. So now we're going back to that 1996 amendment, which had been passed and then was kind of dormant, and now suddenly the department had a bunch of these applications, and they looked weird to them because, you know, you have a for-profit ownership entity that's owning the project. They didn't really know what to do with the statute, because the statute clearly said that they should disregard it, but they didn't know how. They didn't know the tax credit financing program, so they couldn't necessarily figure out how to apply the Korsen, you know, test, the constitutional analysis test, in a cogent way to make sure that these, you know, tax credit projects worked for a charitable property tax exemption purpose. So what the Department of Revenue did was they convened a working group that involved representatives from the Department of Revenue, from a couple of the assessors' offices, the City of Chicago, the Illinois Housing Development Authority, and then a couple of not-for-profits that were championing this work. And so over the course of 2 to 3 years in ongoing discussions, they developed a series of rules and regulations that speak to tax credit projects, tax credit finance projects. And it basically says, if you are going to pursue a charitable property tax exemption for tax credit projects, you need to meet these following criteria. And these following criteria were developed as a way of addressing the Korsen requirements and the unique world of tax credit financing. And so since those regulations were adopted in 2011, I believe, the tax credit projects are now actually starting to pursue property tax exemptions again. The great thing about these regulations is, again, we have an investor that's buying our tax credits. When Nick is selling his credits, he's going to meet with Erica, and he and Erica are going to form a 15-year agreement, because the tax credits that I talked about are earned over they're earned over a 15-year period, but you receive them over 10 years. So you guys have a long-standing relationship that's going to be documented in a partnership agreement. And we have to build into that partnership agreement certain protections for the 501c3 to make sure it qualifies for charitable ownership and charitable use. And so what happens now, Nick would sit down with Eric and with the regulations the Department of Revenue adopted and said, these are the regulations that we have to live with in order to get this, or that we have to satisfy in order to get this charitable property tax exemption. Can you live with them? Because there are concessions that you have to make as the for-profit limited partner investor to make sure that we can qualify. So one of the great benefits of this rule is it facilitates this conversation before the project closes, and we're drafting all the necessary provisions into the partnership documents to get the exemption. So that's kind of the history, that this trajectory that we've been on, because I think it does inform. And we learned a lot about how the department looks at these type of projects through those discussions. So sadly, the 202 and 811 programs, Congress stopped funding those in 2012. So there's still one or two more in the pipeline from earlier congressional appropriations, but those programs are pretty much done. And then so we're not really pursuing exemptions for those type of projects, but we can pursue exemptions for affordable housing projects that aren't HUD financed, but not necessarily tax credit financed as well. As long as you have your charitable mission, we can pursue an exemption. I'll come back to that in a second. It looks like we have a question.
We have quite a question. Okay. I want to make sure I'm understanding this correctly. If I have a nonprofit status and connects with a for-profit entity that offers services such as affordable housing, which operates within my organization's mission, I could qualify for exemption credits and basically partner with a for-profit and sell my credits and utilize funds received to fund my organization's project.
That's a good question.
Yeah, could you repeat that again?
Yeah, okay.
Because it was a long question.
Okay. I want to make sure I'm understanding correctly. If I have a nonprofit status and connects with a for-profit entity that offers services such as affordable housing, which operates within my organization's mission, I could qualify for exemption credits and basically partner with a for-profit and sell my credits and utilize funds received to fund my organization's project.
Clarify the for-profit investor.
Yeah,
I
so
think that's where the clarification needs to be.
What I'm talking about is solely in the context of a low-income housing tax credit financed project. So we only have a joint venture with a for-profit in that context. If we're doing a affordable housing project, again, Nick and Erica decide to do a joint venture and they're not using tax credits, and they go out and they develop supportive housing for homeless women, let's say, and they each have an ownership interest in the project. You're not going to get a property tax exemption because your for-profit ownership is going to prevent it. Okay, we can, only in the context of the low-income housing tax credit, get the fact that we have a for-profit in the ownership structure. We can get that approved by the Department of Revenue only if we are able to meet all those specific regulations. So I hope that answers the question. And the sale of the credits, just to be clear, again, we're only talking about the sale of federal low-income housing tax credits, and using the proceeds of that sale. Those dollars have to be invested in affordable housing. They can't be used for any other charitable purpose. It's specifically for affordable housing development.
This is complex. I mean,
It is complex. Yeah,
so,
the tax credit financing is complex. Yeah. And one, this may be a very helpful way to think about your project when you're trying to figure out, can I pursue a property tax exemption? regardless of what your financing is. And this was a question that the Department of Revenue posed to us back in that working group. So Nick, again, is my 501c3 developer, and he goes out and he's going to develop housing, affordable housing for low-income elderly. And he builds it on the northwest corner of 2 intersecting streets. On the northeast corner of those same 2 intersecting streets, Erica, who is a for-profit developer, says, you know what, there's a huge need for affordable housing for seniors in this particular community. So I know Nick has built his project. He's got 40 units in his project, but there's a need for an additional 200 units. So I'm going to build 40 units of housing for very low-income elderly right across the street from Nick's project. And the Department of Revenue is going to say to us, and to you when you're thinking about your project, why should we give a charitable property tax exemption to Nick's project when Erica has built the exact same thing and is serving the same population? She's for profit and he's not for profit. What's the distinguishing factor? It's not enough just to be a 501c3 to qualify for the exemption. So what they said is you have to do more than housing. It has to be housing plus something. It has to be housing. And that's where we get into support services is really kind of the distinguishing thing. So Erica may be able to finance and construct and sustain an affordable housing project for low-income elderly, but she's not going to be able to provide kind of the wraparound services that those tenants need because you don't have the money or the resources to do that. Again, she's getting restricted rents, so unless you have extraordinarily deep pockets and a charitable heart, notwithstanding your for-profit exterior, you're really limiting your stuff to providing the housing. The 501c3, however, you're doing something different. You're providing those wraparound services in that building so that you can say, here's where my charity is. And so, you as a 501c3, you're going to, if a tenant comes to you with a problem that may be financial, they don't have food or whatever, you're more likely to say, okay, I'm going to, solve that problem for you by using these resources. And so it's one of the things we say, if you're doing those kind of in-kind donations or assistance to people as a 501c3, keep track of those, because that's one of the things that distinguishes you from this for-profit that's built the exact same project across the street. So it is kind of a housing plus model. You have to always think about how you distinguish yourself from the other for-profit entity.
In your practice, have you seen proportionate allocations, one for mixed income housing of the low-income housing tax credit, and 2 for mixed use projects with low-income housing tax credit and like a new markets tax credit?
So the question is, are we seeing kind of a proportional allocation of exemptions based on uses of the property? So you could have, in the mixed use context, you could have low-income units, and then on the first floor of the building, you're going to have commercial retail, for example. Oftentimes in the tax credit world or the new markets world, for reasons unrelated to the property tax unrelated to the property tax exemption, you are going to create a condominium ownership structure where the commercial retail space is owned by an entity separate from your entity that owns the affordable housing units. So in that circumstance, you would just be applying for the affordable housing units and for the PIN associated with that, and you wouldn't even look to the commercial retail space. I've not actually had a situation where we've gone in for an application where there's retail space involved, but I think what would happen is if we could prove charitable ownership and charitable use for the affordable units, we would get a prorated exemption, and they would say 80% of your property is exempt, and the other 20% would be taxable. And actually, I take that back. In some of these HUD 202 buildings that we've been able to get exemptions for, sometimes there will be a beauty shop that is, on the ground floor of the building for the tenants, for the seniors. And that beauty shop, if it's leased to a beautician, they want to see the lease. you know, if it's for more than $1, they're going to say that is a retail operation, say for-profit operation. So we will exclude that from the determination. So you may get a letter that says you're 80 or 95% exempt. One thing that they also exclude, interestingly, are property manager units. So the fact that you may have a 49-unit building, 48 of those units may be affordable restricted units. The 49th unit is the manager's unit, where you just have one of your staff members, you know, living in the building, kind of keeping track of everything and providing assistance. There's unfortunately a series of cases that say that manager's unit isn't part of your charitable mission, even though they're actually kind of helping to facilitate that, and the courts just rejected that argument altogether and said that manager's unit is going to be taxable. So again, you can have kind of a bifurcation. The property tax code, to get into the second part of your question about kind of mixed units now. So when I'm thinking of that, I'm thinking of, we have 100-unit building. 80 of those may be tax affordable units, and 20 of them may be market rate units. So you're not having, they're not restricted by income or by rent. The Department of Revenue in the property tax code says you have to have 100% affordable units, but they told us through these conversations that they would be willing to accept an application where you had some market rate units, but you were primarily or substantially charitable. And they would give you a prorated, again, kind of 80-20 based on your unit count. But that's not been, at least I haven't tested it, but they've said that that's available. So I hope that answered your questions.
Yeah.
Are there questions online?
Yep. Okay. If you have donated property for affordable housing, how do you submit an application for a waiver of tax or a reduction in taxes to be paid? Is this possible?
I think that was the question you asked answered at the outset.
Donated property that has back taxes, existing back taxes, I do not believe there is a way to get a waiver. There may be a way to reduce the tax obligation from the prior years. There may be a way to reduce the tax obligation going forward. Like I said, there are classes, there's incentive classes for taking over abandoned property. But as to eliminating all existing tax obligation on donated property, I do not believe that there is an avenue to that.
That's certainly something that keeps coming up.
Yes.
So
yes.
yeah, for
Yes,
charities that are
there's a way to
looking at doing it.
there's a way to significantly reduce it. I can tell you that for sure. I do not think there is a way to eliminate it just because it runs with the property. Fortunately.
Any other questions?
Thomas.
Yeah, so when you talk to investors, one of their main hang-ups is the non-eviction policy, and some of the thoughts are that, you know, if you have a building that has rental subsidy, that you're kind of limiting that risk somewhat. And my understanding of some of the rental subsidy programs is that they have some limitations on your ability to evict tenants, and I'm wondering, you know, the non-eviction policy in this charitable use, how much more onerous that is owner than regular Section 8.
So, so Thomas was asking about the non-eviction policy, and before I actually get to your question, let me, that's actually where I was going to segue next in the presentation. So let me explain kind of the background of this non-eviction policy and what it means in the context of the Korzen tests that Nick talked about earlier. So, as I mentioned at the outset of my presentation, that history, the trajectory, this non-eviction policy really kind of came into play in 2002, 2003 when the Department of Revenue put the brakes on the exemptions and HUD got involved. What this particular policy speaks to is the requirement of whether, or the question in the Korzen analysis of, are you placing obstacles or barriers to receipt of charity from those that are intended to benefit from your charity. So if you think about it from the context of a 501c3, you're going out and you're building affordable housing for the purpose of taking care of those in need, providing them safe, stable housing. If they can't pay you, but you're expecting them to pay you rent in accordance with the lease. If they are otherwise a good tenant, but they can't pay you rent because they lack the means to do so, the Department of Revenue says, well, it seems counterintuitive for you to evict them and put them back on the street, back into the conditions that you were trying to address in the first place, simply because they couldn't pay you rent. So they came up with this idea of the non-eviction policy for demonstrated inability to pay rent. If you have this non-eviction policy, then you are not creating any barriers or obstacles to receipt of your charity. And your charity is, again, the affordable housing with the support services and all the other good deeds that you're doing in your project. The non-eviction policy for demonstrated inability to pay rent has a lot of negative connotations associated with it, because the concern always is that someone's going to think, wait a minute, if I can live here for free, I'm going to figure out some way to live here for free. And then your projects, you know, these projects are operating on thin margins to begin with by virtue of the limited rents that you can collect. You're at the risk of having your project go underwater because you're not bringing in the rent revenue. If you have one tenant who tells 3 other tenants that she's not paying rent, all of a sudden you have 4 tenants that, you know, so everyone sees the problem, your rent revenues go down significantly. The important thing, though, is that it's a demonstrated inability to pay rent. When these tenants are seeking to live in these projects, they have to prove that they're income qualified to begin with. There are going to be affordability restrictions. You have to earn less than 60% or sometimes 50% or 30% of area median income, depending upon your financing structure. So you know, as a property owner, what their economic situation is when you're signing the lease. So if they come to you 6 months later and say, I can no longer pay you rent, you're going to say to them, okay, prove it. And if you can in fact prove that you're unable to pay rent, then you can qualify for protection under this non-eviction policy. So as long as you adhere to all the other terms of your lease, I'm not going to evict you for your inability, simply your inability to pay me the rent that you otherwise owe me under the lease. Now, the Department of Revenue, there are a couple of unique catches to this non-eviction policy. One is it has to be incorporated into your organizational documents. So getting back to my joint venture, my limited partnership agreement between Nick and Erica, one of the things that's going to have to be in that partnership agreement is a statement that, yes, we agree as between these partners that if someone has low income and they're unable to pay rent and they demonstrate that to us, Nick's not going to evict them. And that's always a big hurdle for the investor to kind of get over psychologically. So it has to be in our partnership agreement. But the more important thing, and this is also what creates great angst, is it has to be communicated to the tenants. It's not enough just to have the policy. If nobody knows that you have a policy and can't avail themselves of it, again, you know, how are you being charitable? So the department addresses that issue by saying you have to communicate this policy to the tenants, and you can communicate it really in 2 ways effectively. One is through an addendum to the lease that basically sets forth the non-eviction policy, and it's an actual attachment to the lease. Or the second is in the form of your house rules or tenant rules for the property, and it may be discussed in there. So you have the organizational component and then the tenant communication component. So now your population in your building is all going to know that this non-eviction policy exists. But they have to prove, again, the inability to pay the rent. And the Department of Revenue has not provided any direct regulations or guidance on what this means. And so there is some flexibility for the owner to figure out how they're going to structure and implement this. In conversations with the Department of Revenue, the easy examples are, you know, just the easy ones. So I'm a tenant and I have $150. I have a heart condition and I have a choice between paying for my heart condition medication or paying the rent. And the Department of Revenue is going to say, that's an easy call. have them pay for the heart condition, don't try and collect the rent. And one of the reasons the Department of Revenue takes this position is, remember, these property tax exemptions may be worth $40,000, $50,000, $60,000 a year. So from their perspective, I'm giving Nick a $60,000 savings. He can afford to apply some of those savings to carry, the person's $150 rent. It only becomes a problem when it becomes 5 tenants or 10 tenants. But 1 tenant, it's very manageable. So the second example is, I only have $125 left, and I choose not to pay rent at all. Or no, let me step back. I have $125 left. I had $800 2 weeks ago, but I lost it because I went to the gambling boat. Again, an easy example. The Department of Revenue is going to say that's grounds for eviction. They're not entitled to protection for this policy because of the decisions they've made.
So is it a monthly thing? I mean, is it a monthly?
Yeah, how do they
Yes.
attest to this?
So it's like if somebody can't pay rent every month, they just come and say,
Right.
still can't pay rent.
Right. We have a client that's actually developed a rather sophisticated way to approach the non-eviction policy. So they have a disclosure to the tenants that the tenants sign acknowledging that they're aware of the policy. And then they say, if you decide that you're going to avail yourself of this policy, here's the form that you have to fill out. And on that form, it requires you to explain what your changed circumstances are, why you've had the change, and getting to all these other factors. Was it, do you have heart medication payments that you have to make, or whatever? So lay out your circumstances for us. They will then take those circumstances plus income certifications. They're going to look to your, give me a copy of your checking account statement. Give me your wage statement if you're having, give us all the documentation. They then take that documentation and have their internal decision makers review it, and they've appointed 3 people to make those decisions. And then they issue, after the decision is made, they issue a written statement to the tenant saying either approved or denied. If you're denied, here's the reason why you're denied. If you're approved, then here are the conditions for your continued participation in the non-eviction policy, and they sign off on it. And those conditions include proving the continuing need. Now, they're not doing it on a monthly basis, but they're saying, we're going to revisit this in 3 months with you. And if you've had a change in circumstances that are favorable, then understand that this is a 3-month grace period. It ends at some point, and you're going to come back to paying taxes. Not paying
Rent.
taxes, paying
Rent.
rent. Sorry. So we don't pay taxes, right? Now, it's also important to note that during that 3-month period where they're not paying any rent to you, you're not kind of accumulating a balance and then going back to them and saying, by the way, now that things have gotten better, you owe me $375 for those 3 months that you didn't pay. Part of being charitable is absorbing those costs, and just again, you're getting a $60,000 benefit. There's things that you as an owner can do. You can set up a reserve at the beginning of your deal to have money available to you if you have those circumstances. So there should be, I think it's prudent and smart to have a retesting, and everybody knows, and again, it's all signed off, so it's clear that you understand that you don't have this kind of continuing right to this non-eviction. So now getting to Thomas's question. How do you address the non-eviction policy in the context of projects that receive rental assistance? In my mind, the non-eviction policy is not a no-brainer, but it's an easier decision to make to adopt the non-eviction policy where you have an outside source, the Chicago Housing Authority or HUD, or somebody that's giving you project-based rental assistance. So getting back to that example, if it's a $500 rent and the tenant's paying $150 and the subsidy's paying the other $350, you're taking less of a risk, financial risk, obviously, because you're only potentially out $150, and you're still going to get that $350 monthly subsidy. what comes along with, and we doing okay time-wise?
We have 15 minutes left.
15 minutes,
So,
okay.
Yeah. I want to make sure we get to.
Yeah, we'll go back to
yeah.
it.
Oh,
So
yeah.
what comes along
And
with
they'll be quick.
5. Yeah.
with those subsidy requirements are restrictions on your ability to evict tenants to begin with. So you have to have, and it's pretty much true for most of these publicly financed projects, that you have to have serious and repeated violations of the tenant lease in order to evict somebody. Again, getting back to the simple idea that if you're trying to help them, you're not going to kick them out the first infraction that they have under your rules. The non-eviction policy for demonstrated inability to pay rent only protects them for purposes of the rent payment obligation of the lease. They still have to comply with all the other terms and provisions of their lease. And so if they fail to adhere to those other terms, even though they're protected by the non-eviction policy for purposes of rent payment, they can still be evicted. So they're engaging in criminal misconduct or whatever the case may be. Something that's a serious and repeated material violation of the terms. And most of the leases will say, the following violations are the material violations, so that the tenants know, if you're doing this, you may be okay, but if you're doing this, that's grounds for eviction. So in the non-eviction, so in a context where you have subsidy that's being provided, but you also have someone that's qualifying for the non-eviction policy, I don't know that it really makes much of a difference, getting back to the investor's concern, because the non-eviction policy is so narrowly construed to that one particular part of the tenant's lease. If they're otherwise non-compliant, they're out. If they are compliant with those other provisions, then you would have an obligation to renew them for the next year, and they would continue to be protected by the non-eviction policy for the rent payment as long as they demonstrated this continuing need. Once that continuing need goes away, that protection goes away, and they're subject to all the terms of their lease as everybody else in the building would be. Did that answer your question?
Yeah.
Okay. So we spent a chunk of time on the non-eviction policy, but it is kind of the hurdle that the investors have to get over in order to go forward with the property tax exemption. Because if you don't have it, the Department of Revenue is going to deny your application basically from the get-go. And one of the things, to touch back on those regulations, what they said to us, particularly because tax credit financing is very complicated, that they're going to view those regulations as their checklists. So they're going to be going through your application, and if they check all the boxes, you're going to get the exemption. So one of the things that we do when you're submitting a property tax exemption, you submit this affidavit of use that explains all the charitable work that you're doing and how you meet the course and requirements. And at the end of those affidavits, what I've been doing now for tax credit projects is I put together a box. In the left-hand column of the box, I refer to each of the regulation sections. And in the right-hand column of the box, I say, look at paragraphs 3, 6, 7, and 9 of this affidavit, because that addresses that particular requirement. And so, it's just a blueprint through the affidavit that
Streamline
says,
your application.
exactly,
approval.
here's the requirement, here's where it's met, here's the requirement, here's where it's met. You can pursue property tax exemptions for affordable housing. It's complicated, and you have to be comfortable with the non-eviction policy, and you also have to ask and answer that important question of, how am I different from a for-profit developer that's building the same housing for the same population? And if you can answer that in the Housing Plus model, then you're more likely to get an exemption application. And so I think Nick's now going to talk about what happens.
What
if
about
you...
holding property for adaptation to charitable
Oh,
purpose?
Yes.
Oh,
Really
yeah.
quick. And
Yes.
Then,
Yeah.
So, and you can fill this in as well.
Yeah, I mean, this is pretty.
Yeah. So if I'm a 501c3 and I go out and I buy property and I know that I'm going to redevelop it for affordable housing, and I subsequently get my exemption. The exemption can apply back to the date that I acquired the property, as long as I demonstrate that during the interim period between when I acquired the property and I closed on my financing, I was taking affirmative steps to adapt that property to its charitable use. So if I buy property in 2014, but I don't do anything on it for 2000, I don't do anything with, in terms of developing an affordable housing project until 2016, I may not be able to get the exemption applied back to the 2014 date. But if I buy it in 2014 and I've gone out and I've hired an architect to start doing my drawings, and I've hired a environmental consultant to come in and do the phase 1 inspection for the property, and if I'm doing all of these activities and I'm applying for my various levels of financing, then the Department of Revenue will apply the exemption back to the date. And one of the things that they require us to do on the affordable housing projects, and this is why the affidavits use actually get quite lengthy, is they want to see a chronology of everything that's been done from kind of day one of this idea for the housing through to the project finance closing and the construction of the project. So we say on this day we hired the architect, on this day we hired the contractor, we started talking to the CHA here, and it's that litany of dates and events to show adaptation of the property for the charitable use.
Perfect. So Nick, do you want to?
Quick question.
There is a question, yeah.
Sorry.
That's
kind
okay.
of related to that. So you are going to be paying your tax up until it's leased up and you prove that you're in compliance, and then you're going to go back and try to get
Right.
some
So
back, but
we're not able to. Yeah. So his question is, when do you basically are you paying taxes until you're able to get your exemption?
Yeah.
And the short answer is yes. And then you go back and through the certificate of error process, you can get those taxes refunded to you, as long as you're able to get that exemption ruling applied, back to the date that you started your charitable activity.
So because it's a year-to-year thing, have you seen investors comfortable enough to underwrite, no tax, or do you see them requiring a big reserve?
Very good question. So Thomas's question is, when we're underwriting these deals for all of the funders to make, nobody's going to lend you money. No one's going to buy your tax credits without you being able to show that your project works economically. And so there's a tension with the charitable property tax exemption because you can't apply for it until you're actually in ownership of the property. And with these tax credit projects in particular, you're not in ownership of the property until all your financing is closed. So you're going to your investors with a pro forma operating budget, and the question is, what do you show for the property taxes? Do you show zero, or do you show that it's a taxable property? And my experience has been that the investors want to see that it's treated as taxable and that you have the ability to cover that tax liability in their operating budget, because they just don't know whether you're going to get the exemption or not.
So that seems like the biggest barrier, especially for communities. I can think of suburbs that have unbelievable tax rates. That just is a non-starter. If you can't underwrite at that. I'm wondering if you guys have heard of any policy changes or anything that's coming down. Anything
As far as like tax rates?
No, I know they're going up. I'm just wondering because this is a problem that's only going to get worse.
No, it's the disparity in tax rates is incredibly problematic for low-income housing, for small business owners. I mean, you should see, you've got a lot of clients in the south suburbs whose tax rates are 5 times what they would be if they were in the north suburbs, and that's, for someone trying to run a small business in that kind of area, it totally defeats the purpose. I mean, it's awful, but I don't think there's any sort of policy change on the horizon.
No one's talking about this.
I mean, we talked about it in my office,
Yeah.
but it's something that does need to be remedied, because you can't promote business coming in and small businesses in the areas that need it, because the tax rates are astronomical. Unfortunately, I don't have a really positive answer for you on that one. Okay, so we will sew this up real quick.
Just one really quick question.
Yes.
So I heard that if there was a nonprofit who was using it for charitable use and not necessarily affordable housing, but they owned it and it was for charitable use, but the funding that they received was overwhelming majority government funding, that they would not be eligible for property tax exemption. Is that true, or is there some type of pushback from IDOR on that?
Okay, you're gonna have to repeat that for me one more time.
I don't know if it's true. It's just something
Okay.
that I heard.
Mhm.
That if a nonprofit owns and would use it for a charitable purpose, property,
Mhm.
but their income sources are overwhelmingly government sources, that IDOR may deny the application.
I don't know that to be true.
Okay.
I don't know that that particular problem hasn't come up with me. I would imagine, and Bill, like I said, Bill will take that because it makes more sense for him to take it. But so many nonprofits have a large source of income is the government. I mean,
Right.
that just would seem to be counterintuitive.
It is counterintuitive, but it is a problem sometimes.
It is,
So
okay.
I've read a couple of administrative law decisions issued by judges, administrative law judges that are hearing these Department of Revenue appeal cases. And it gets back to one of the causing factors of where is your support? Is it coming from the public in the form of donations, or are you mainly getting paid from some other source? And they will look at your financial statements, and if it's lopsided, they may consider that as a problem. It shouldn't be a problem that you have a disproportionate amount of government funding, because that is, as you were saying, that's just the reality of 501c3s. If you look at even the very successful charities, their public donations are a very small part of their operating budget, and it's mainly government support.
Right.
But that doesn't prevent the Department of Revenue and these administrative law judges from honing in on the financials and saying, okay, show me where you're getting charitable support, that you're meeting this coercion requirements, and I forget which one it is.
It's
But
two, I think.
Yeah, it's number 2, but it goes to what support you have, and that was a problem. Getting back to the 811 world, it's the same. They had that reaction like, you guys, you're getting money from the government to build, you're getting money from the government to operate. How are you being charitable? And that's really the person that raised that question to you. They really need to think about in the context of showing how they're charitable, notwithstanding all of these government funds that they necessarily rely on to do their work.
Okay, good, thank you.
Okay.
Sorry, Nick, do you want
No, that is fine.
You're
All right,
denied.
to sew this up, we're going to cover real quick what happens if an exemption application is denied. One second. Okay. So your first thing is appeal to the Illinois Department of Revenue, either informally, and if that doesn't work, a formal hearing. If you think you have a really strong case, that's obviously winning a hearing and getting an exemption put in place is the best case scenario. Your next step is going to be a valuation appeal. If you don't get an exemption and it's a property you want to / need to hold on to, then valuation appeal is really your only other avenue. So that comes in 3 different shapes. The first level is the assessor. The county assessor is the first level of appeal, and notable for nonprofits and for low-income housing. The assessor is the one who decides on what class a property is and whether it qualifies for incentive classification. So the first thing you're going to look at, if you have a property that's not exempt, but you still want to use and want to have, whether it qualifies for an incentive. Abandoned property long vacant, property low-income housing that's for-profit that doesn't qualify for an exemption will often qualify for an incentive class. Incentive classes will have a reduced assessment ratio for a set period of time. A property normally assessed at 25% will be assessed at 10% for a large portion of however long that's in place. Besides that, it used to be that there was more of a tangible benefit for housing, because housing, all apartment buildings used to be assessed at more than 10% of market value. That is prior to me doing this for a living. But now everything's assessed at 10% of market value. So the tangible benefit to an incentive class for an apartment building, low income or otherwise, is not totally there. But it sometimes still can behoove someone who owns an apartment building that's not exempt to try and qualify for an incentive class, either A, for an investor, B, for some of the intangible benefits. Your building will get better treatment for valuation purposes, higher expense ratios, higher cap rates, etc. If it's a demonstrated low-income housing building, we represent a number of low-income housing properties that are not exempt. They're essentially for-profit entities, but they're low-income housing. So that is what happens at the assessor. There's one level of appeal. Next is the board of review. That is where, like we said before, where you go first step in the exemption application. It's also the second step in the valuation appeal process. Essentially a check on the assessor, and then you'll receive a decision from the board. After the board, for valuation appeals, your options are either the circuit court, which I can't really speak to a circuit court appeal outside of Cook County, and PTAB. PTAB is short for Property Tax Appeal Board. That is the state level check on county level assessment. So the board is a check on the assessor. PTAB is essentially a check on the board, and that is. It's worth noting that is the circuit court and PTAB are down the line. If you have a valuation appeal, the assessor and the board both make their decisions prior to assessments being finalized. Like the assessor proposes an assessment, possibly reduces it. The board will then possibly reduce it, possibly not, and the assessment will be finalized. Tax rates will then be set, and tax bills will come out based on those numbers. Any relief from the circuit court or PTAB comes after taxes have already been paid in the form of a refund. That is the large distinction. So if you're in a situation where you need to go to PTAB for something, you're going to have to pay taxes in roughly the amount that you're protesting for a number of years. And that is about that. Oh, we have another question. One more question.
Good.
One more question.
Can appraiser valuations affect the tax you must pay? Is it wise to get one?
Yes. The short answer is sure. Okay. Sorry. Yeah, I got to repeat the question. Can appraiser valuations affect the tax you must pay? Is it wise to get one? The short answer is yes. The large answer is oftentimes an appraisal is close to or best evidence of valuation. Short of a purchase price, an ad valorem appraisal as of as of January 1st of the year in question is going to be the next best thing. It's usually the primary evidence if you're appealing a property that is commercial and owner occupied. It's usually, you often use them in homes. You rarely use them with apartment buildings, but there are cases where it is wise to use them for an apartment building. But yes, anything commercial or industrial that is owner occupied or occupied by an entity related to the owner, those are treated as owner occupied. An appraisal is what you're going to need. Okay.
If you get denied and you appeal, when can you apply again? Or is it
Okay.
better to go through the full appeal process before applying again?
Applying for an exemption?
Yeah, right.
Um,
Like, for example, say you were denied and you have changed use, and
Sure.
say there was something with the waiver or fee structure or something, then you put that into your organizational
Mhm.
document, so it's much more clear now. Can you reapply, or how
okay.
soon?
The question was reapplication after
Denial.
denial of an exemption application, be it for a change in use or maybe explaining a better way to explain oneself, something like that. As we had said, the first step in the exemption application process is always the Board of Review in the county. You are beholden to their calendar. So the Board of Review opens in Cook County. It opens near the end of the summer, beginning of the fall. Generally, they have 4 dates where they take exemption applications. That is always going to be your first step, be it a reapplication or otherwise. Yes, it's going to be the board on the board's calendar, and that's
So
really
once a
that.
year?
Yeah, so I
Yes, well, yeah, depending on
you're
when you
yeah,
hear from
you're
the
applying
Department of
yeah,
Revenue.
you're applying on a for a particular tax year. Now you may
Right.
not be able to it may excuse me, maybe with the timing of the board of review, you're submitting a 2014 application actually in January 2015 or March 2015. But if I have a 2014 application and I get a denial letter in 2014 and I've corrected everything, I'm going to put an application in for 2015 in the whenever I can file a 2015 application. At the same time, I'm appealing the 2014 denial
I see.
so that
Yes.
I'm protected, because I may ultimately lose 2014 and pay taxes in 2014, but I fixed the problem and should be able to get the 2015 exemption application.
And you definitely, if you ever are denied, you should definitely leave that process with an understanding of why you were denied. I know, the Department of Revenue letter doesn't really come with a whole lot of explanation.
Right.
But if you someone should be contacted at the Department of Revenue for an explanation so it can be corrected. That's just common sense. That's just worth noting.
Really helpful. Any other questions? Online or in person? Well, thank you so much. This has been really informative. Thank you so much for sharing your expertise. We mentioned before, it's really complicated. So this is really, the purpose of this was to give you a basic overview. Obviously, every situation is different. If you have any questions after the seminar, feel free to email them.
Okay, if anyone has
Thank you.
questions,
Yeah.
feel
Yeah.
free to give my email. That's fine.
We'll